Morning, Your Honors, and may it please the court. David Costello for the state of Florida. I'd like to reserve 5 minutes for rebuttal.
Got it.
I do want to jump into the jurisdictional issue, but before I do that, I just want to frame this case. This case is about whether the government must regulate by purchase when it seeks to alter a common carrier licensing scheme of its own creation. The answer to that question is no, and this court should make clear that neither the state nor the county are liable for a taking here. If, however, the court is not inclined to rule that way, it should reverse the grant of summary judgment because if the taking has occurred, the county is liable. Now, of course, I want to jump into that jurisdictional issue, and just to set the scene, there are two appeals here. The state has appealed the denial of its motion to dismiss and has appealed the grant of summary judgment for the county. I don't want to say that we are only appealing the denial of the motion to dismiss, and I don't think we could say that because the reason this court would have jurisdiction over the motion to dismiss is because it is directly related to the grant of summary judgment for the county that the state is appealing. So that's one appeal. The other appeal is the plaintiff's appeal from the grant of summary judgment for the county. They're not touching the motion to dismiss. The question that I think was asked here is, can this court consider whether there has been a taking? And it can on either of two theories. One, it can consider it in reviewing the denial of our motion to dismiss because that argument was raised. And even though the court did not squarely address it, we raised it twice and the court did not grant our motion for summary judgment. So we do think it's fairly before this court. But of course, I don't think this court needs to get...
You said...
I'm sorry.
You're not appealing the denial of summary judgment.
No, I'm sorry. I misspoke. To correct that, we did not move for summary judgment. We filed a motion to dismiss. And so we appealed the motion to dismiss and also the grant of summary judgment.
The way you appealed the grant of summary judgment, I just want to make sure I understand how you say you did that, since in almost any other world, a co-defendant that is still on the hook would have a hard time appealing a judgment in favor of another defendant, unless you convince us that you fall within the language of 9.11K about directly related to, right?
I don't think that's right, Your Honor. I think that there are second district cases, and we cited this more so in our notice of appeal, and I can get that for you on rebuttal. But there are cases that say that actually a co-defendant must appeal a grant of summary judgment for another co-defendant, otherwise we can't seek contribution. But of course, there's no dispute here that the state has the ability to appeal the grant of summary judgment for the county as a final order. And the question would be, is there jurisdiction to consider the motion to dismiss?
So why is it directly related?
Well, it's directly related, Your Honors, because the motion for the grant of summary judgment and the denial of the state's motion to dismiss turned on the same core conclusion. And it was the district court's conclusion that, I'm not going to say a taking has occurred, but if one occurred, it must have been the state and not the county, because the state abolished any medallions, not the county.
But if it said I'm not determining today whether a taking occurred. Okay, so you have one of your arguments in the motion to dismiss was, if it occurred, it wasn't us.
Yes, Your Honor.
So can you bootstrap your other argument, which is, in other words, can you bootstrap your alternative grounds for motion to dismiss, which is that no taking occurred at all, given that the trial court expressly said I'm not deciding that?
I take the question, Your Honor. I wouldn't say bootstrap, but I think the proper way to look at this is to look at the text of 9.110K, and that says that this court may review an order that is directly related to a grant of summary judgment. That's the whole order, and that order rejected our argument that there was no taking. I'll just
so your argument is basically that the order on its face essentially vests us with jurisdiction because the findings and conclusions that are in it tie so closely to the question of your liability or not, that the only way we can fully review the arguments that are being made as to the summary judgment for the county is to include you.
That's exactly right, Judge Brett. And I'll also say,
you said an order, am I looking at the wrong subsection? It says the scope of review of a partial final judgment may include any ruling or matter occurring before the filing of notice of appeal, so long as the ruling or matter is decided is directly related. Where did you say it?
Of course, Your Honor, I misspoke there. I construe order and ruling or matter as being coterminous in the context of that phrase.
I was just parsing different rulings and matters within the order, and your response was, well, you can review the whole order because it is directly related. Well, my point is, why shouldn't we, and I use the word bootstrap, and that didn't mean it pejoratively, but you're bootstrapping a ruling or matter that is not directly related, given that the trial court arguably making whoever the other party is on this, they're arguing for them, it was arguably not determined to one that was, which is they're on the hook, not us.
Well, I think you can construe, the trial court's entire order as being one matter, and all of these issues are very intertwined together. And so the argument that they're
I'm just telling you why, okay, that's fine, you could do it that way. Why shouldn't we under subsection K of 9.110 say, we are going to accept jurisdiction of, but we're only going to determine the question of who's on the hook, because yes, that was a ground for your motion to dismiss. We will review the denial of your motion to dismiss insofar as the ground that was directly related to the ruling, which is that the county's not on the hook, is at issue, but we're not going to accept jurisdiction of the ground of the motion to dismiss based on whether a taking occurred.
Two responses, Your Honor. One, if this court I think that the proper way to look at ruling or matter is to say, look, this is a takings case. Whether there has been a taking is certainly directly related to whether the county is going to be liable. And the court decided this all in one fell swoop, so we have a very close connection.
Broad reading, which is permissible, which of directly related to ruling or matter.
But I do want to note that we don't live and die on that jurisdictional issue, because whether this court can consider whether there has been a taking does not turn on whether there's jurisdiction over the motion to dismiss, because indeed, whether a taking has occurred can be held by this court as an alternative ground for affirmance for the county under the Tipsy Coachman doctrine. And this court—
So we can affirm the order getting the county out of the case on the Tipsy. But can we do that if we also agree that the county was not on the hook? Can we get to the Tipsy Coachman doctrine? You're absolutely right, Judge. The county wasn't on the hook, even if there's a taking of the state, and they're responsible for everything. However, we're also going to resolve the Tipsy Coachman argument, even though we don't need to.
Certainly, Your Honor, because those would be alternative holdings that this court can render.
We agree with you, trial court. Also, you're right for this other reason.
Certainly.
Okay.
Well, and courts give alternative holdings all the time. And I'll just note that the plaintiffs, I think everyone in this case wants to get it resolved on whether there has been a taking. And because for a few reasons. One, the trial court has been presented with this issue a few times now. Two, these involve all legal issues in our
ask you
view.
a question. What you're asking us to do is effectively, I think your home run, bases loaded, lights out, play, is we affirm for the county and we reverse and direct entry of judgment in your favor on the motion to dismiss.
That would be our home run, yes.
Right. And that's really what you want us to do, isn't it? You want us to legally conclude that what the trial judge found as to the county is correct. And you want us to make the legal determination that your motion to dismiss was well founded for presumably the same reasons or similar ones at least, that buttress the ruling in favor of the county that we would affirm.
That's right, Judge LaBrite, that would be our home run. But of course, if this court were to affirm on the alternative ground that there has been no taking, even if it doesn't think it has jurisdiction over the denial of our motion to dismiss, that would be law of the
You want us
case.
to write an opinion saying the county was on the hook along with the state if there had been a taking, but there wasn't a taking, and you want to go back and say, well, hey, should we hear our motion to dismiss again?
Your
Given
base
the law of the
hit, your
case?
base hit is that we reverse the finding on the county and send you all back and let the trial court start from scratch.
And I would say my double is if you don't reverse, if you affirm, you don't say that the county was the one who was on the hook. You just say, we don't need to decide that because there's no taking here, which is entirely in line with pretty much all the cases that have construed.
It sounds a lot like a triple to me.
I would take the triple. I would take the triple, Judge LaBrite. I don't know if I'm fast enough for that, but I'll take it. So for all those reasons, this court does have jurisdiction and can consider the issue. And of course, the plaintiffs want this court to consider the issue. And there is no taking here for two reasons. First, plaintiffs lack a cognizable property interest in their medallions. And second, even if they had one, there could not establish a taking under the relevant takings tests. And so
What is the relevant takings test?
well, it's been a little confusing in the briefs. My friend on the other side has said that this court can consider the takings test unmoored from the Penn Central test and the Lucas test, and just simply ask, has property been taken without just compensation?
It seems like our court may have already answered that question in the Galaxy Fireworks case.
That's correct, Your Honor. I mean, this court has consistently followed the tests that have been opined on by the Supreme Court of the United States. And that makes sense because the word taking, that's an ambiguous term. It needs construction, and the construction has come in the tests that have been created by the Supreme Court, Penn Central, Lucas, Loretto. So that's the test that applies here. But before we get there, plaintiffs first have to show that they have a cognizable property interest. And this was a point that you were touching on, Judge Atkinson, in the Dennis Mellencamp case. That case makes very clear that when you have a regulatory regime like this one, plaintiffs do not acquire a sufficiently concrete property interest in their medallions at the start.
But in those cases, did you have a scenario like this where you actually had a legislative pronouncement saying this is private property, and then apparently legislative repeal of that prior pronouncement?
Admittedly, no, Judge Lucas, but
So what do we do with that statute?
well, I think we have to construe what the legislature was really saying when they used the words private property, because as Judge Posner has explained, property for purposes of the Constitution need not mean the same thing as property for purposes of a statute. That's a very broad phrase that takes different contexts. In fact, in the due process context, property is construed more broadly than in the takings context. So for example, like a teacher has a due process right in her job, but if she were fired, no one would ever say that there's a taking.
The problem with that notion that's an apple and orange comparison. The reason why is because not only did the legislature say that it was private property that it has private property interest in, this weird kind of passive voice usage, but then goes on to say and include the kinds of things that we associate with private property that has interest that will be compensable under the Florida Constitution here, since I think it's only a state constitutional claim-based taking. Is that correct?
I believe.
Yeah. So we're talking about fair compensation, and the legislative language includes language that traditionally appends to a recognized private property interest.
Well, the distinction here, Your Honor, is that, well, first, just to touch on the underlying premise, the property right that you're referring to is the right to transfer, but that's not language that gives you all the sticks in the bundle of property, the right to exclude, the right to use, possess, control. That's just one limited transfer right. And in fact, as Dennis Mellencamp recognized, that transfer right, even standing alone, is not sufficient to establish a concrete property interest. And I think that case is really the answer and what this court could follow if it wanted to write this decision. There, the city of New Orleans had a taxi cab scheme. It was very similar to this one. And the city, just like the PTC here, granted a limited transfer market. And the city spotted that there was a secondary market, exactly like you were saying, Judge Atkinson. And the city changed that scheme. It took away the transfer right, and the plaintiffs sued for a taking. The Fifth Circuit rejected it and said that they do not.
They're just merely just curtailed it. It made it instead of mandatory, it made it discretionary. It's still transferred. Go ahead.
Right. But they took the ability of the plaintiffs to transfer it as they wanted to. Yeah. And so the Fifth Circuit said there's not a cognizable property interest here for three reasons. First, the plaintiffs lack the ability to possess the government free of regulatory intervention because the city retained the broad right to alter or extinguish medallions. That's exactly the right the PTC had here. By the rules or by the statutes that created the PTC had the power to revoke medallions, to suspend medallions.
So is it your position the legislature's abolition of the PTC is the same as the PTC revoking medallions?
I would say that it is consistent with the power that the government has always carved out for itself. But I think the best way to look at this is to think, how many sticks in the bundle did the government retain for itself and prevent the plaintiffs from obtaining here, given the regulations that it placed in the PTC scheme? So, again, the PTC had the right to alter and extinguish medallions. So it retained the right to prevent them from excluding the government from regulating their medallions. Another important fact was, and this was the Mitchell Arms case that I think Dennis Mellencamp was citing to, the PTC retained the ability to expand the cap on licenses. It effectively could blow up the cap on licenses and flood the market with
Which
licenses.
case you talking about?
The Dennis Melancon case.
Oh, the same case.
Yeah, same case. So in that case, the court said it is very persuasive to us that the city could always change the cap on the number of licenses. So plaintiffs lack the ability to exclude others from entering the market, making their property interest significantly less concrete. And that's exactly what we have in this case. And in fact, that's what the Third Circuit found in the Newark cab case, because there the court found persuasive that the plaintiff simply did not have the right to exclude others. The city could always flood the market. Finally,
Your opponent's gonna say this isn't a market flooding, this is a complete abolition. Which is, I think, a little bit different than what the case that you're relying on, right?
yes, Judge Lippert, this is not an Uber or Lyft case, but I'll note that Dennis Melancon was not an Uber or Lyft case. The teaching of Dennis Melancon is that plaintiffs, to acquire a concrete property interest in a taxi cab medallion, have to acquire the typical sticks in the bundle that give you a concrete property.
Well, wasn't the question, the distinction between, not between this and a Uber case, but between what the authority government did in the New Orleans case, which was just restrict the right of transferability, whereas here, they did away with the medallions altogether, I think was what Judge Lippert was asking, and I think she could correct me if I'm wrong.
No, certainly, Your Honors, but I think that the teaching of Dennis Melancon or the holding of Dennis Melancon didn't so much turn on what the government did. It turned on the fact that plaintiffs didn't have a cognizable property interest in the first place. And because they lacked that property interest, no matter the government's action, when it regulated, it did not cause any taking. There was nothing to take. And that's entirely
So no matter
consistent.
the level of erosion or infringement, it didn't matter because there was no property that would ever be subject to any taking, without regard to how invasive the taking was.
Right, and you see that all the time in the context of,
And that goes back to the question I had for your opponent when it's up, which is if what the plaintiffs had a right in was something that the PTC had control of and could issue. And I guess this is really better directed to your opponent, so be on alert. Isn't it dependent on the existence of the PTC such that there is no property right?
right, like I do think a way this court could write the opinion is the state didn't take anything, it's just dependent on the fact that the PTC existed. But an alternative holding as well would be that, even if the state could be said to have by abolishing the PTC have caused any sort of taking, it didn't take anything because there just were no property interests under the takings clause to begin with.
Can you frame that within the Penn Central test for me though? Because you're referring to that almost as if we were writing on a clean slate and just defining taking for the first time, and we're not, obviously. So why is it that the legislature's use of shall have a private property interest in these medallions and they can hypothecate them, assign them, transfer them? Why does that not fall within the character of government action, the plaintiff's reasonable investment back expectations and or the regulations economic impacts of plaintiff's property?
Well, I think it's important to frame what the relevant test is under the takings clause, because there's two parts.
I'm going by Penn Central.
No, of course, Your Honor, and I agree that Penn Central applies, but before Penn Central applies, the court has to determine that there's a cognizable property interest to begin with.
So the test doesn't bear upon that.
No, it does not, Your Honor, it's a totally different test.
So
So
reduced to simplest terms, your point is there was nothing to be had other than what the PTC could give, and the PTC, the legislature abolished it, so there was nothing to be taken away.
right, like I think that if the PTC was abolished, so there was nothing to be taken, and that's one way to frame it. The other way would be if I were to spot my friend on the other side, that if we reached by abolishing the PTC, we could effectively took medallions. My response would be, well, no, we didn't, because you didn't have a concrete property interest under the takings clause to begin with.
By the time you get to Penn Central's test, you're saying it presupposes a cognizable property interest to be taken.
That's exactly what
That
it
would
does.
survive the abolition
That-
of the PTC.
Exactly. So, if we're in Penn Central world, you'll have already concluded that plaintiffs had a cognizable property interest. That's the only way that we can get there. And, if you want support for this, the cases we cite from the federal circuit really explain this well. If you look at cases like Conti and Mitchell Arms, and also Dennis Melancon, because it was this kind of case, they all are holding that there's no taking because there just was not cognizable property to begin with.
So what you would circling back, you would tell me, Lucas, don't even get to Penn Central You don't need to worry about the balancing out those elements because this is just cannot be considered property.
Under this particular licensing scheme, yes, but I would also say that even if we got to Penn Central, the state still would win and would be able to show that there was no taking. For a couple of reasons. If you'd like me to turn to Penn Central, I'm happy to do that, but I would like to.
Eventually, I'd like to hear your thoughts on that.
Of course.
Just in case I conclude in my mind, yeah, this was a property interest. Okay, then we get to the subsidiary question in any inverse condemnation cases. Well, was it taken?
Sure. And well, and if I can just wrap up on
As a
cognizability.
matter of pleading too, which is kind of because of the unique procedure.
Sure, but of course, in Dennis Melancon, the court made all these conclusions just based on the law. And the Checker Cat case from the 11th Circuit says that you really have to look to the law when determining whether someone has a concrete property interest.
Well, whether or not there's been a taking is an issue of law,
Certainly.
right? Which the judge has to decide. That does not get submitted to a jury.
Yes, Your Honor. And so what I would say is this is all legal. All the questions here are legal. And so we don't need to worry about the fact that it's on the pleadings. But I'll just say two things. One, on cognizability, I don't think the fact that there's the words private property here, prevents you from concluding that there's not a cognizable property interest, because as Judge Posner said, the property means different things in different contexts. We have to look behind that label and figure out what was the legislature really saying when they used the words private property. And plaintiffs say that our reading would make it surplusage, but it certainly isn't, and that's for two reasons. First, the legislature was endowing a property interest. It was endowing a limited transfer right. And we think that the reason they used the words private property was to make pretty clear, medallion holders, y'all can transfer these medallions. But that does not mean, given the limitations on the transfer and all the other sticks in the bundle that they were lacking, that they acquire the concrete property interest. And second, I think this is important. Well, like I was saying before, property for the due process clause is broader than property in the takings clause. And I'll just say that I think that another thing that the legislature was thinking about here was to make sure that these medallions had due process protections. But that's far different from saying the state has to pay when it wants to abolish a scheme to protect the public or to adapt to more modern times. And now just to touch on your Penn Central point, because I do want to get to that, Judge Lucas. Plaintiffs cannot establish a Penn Central taking here for three reasons, even if you were to say that there was a concrete interest. That's a balancing test. It turns on the character of the government's action, the investment-backed expectations, and the economic impact. All three of those factors cut for the government, and the first two do so overwhelmingly. On the character of the government action, as this court said in Galaxy Fireworks, and as the Florida Supreme Court said in Graham, when the government acts to protect the public, it's less likely to have committed a taking. And that's exactly what the government did here. Taxi cabs are dangerous entities. They're common carriers. They require regulation to make sure they don't hurt others. For that reason, the state of Florida has always regulated them.
So this is in the back end. The government acted to protect the public in taking the medallions. It doesn't matter whether they acted to protect the public in creating the medallions.
No, Your Honor, I wouldn't say the government acted to protect the public in taking the medallions, because I think if you concluded that we've already lost and there's a taking. I think the proper way to frame this is.
Penn Central asks. Okay, go ahead.
I think the best way to frame it is, did the regulation that plaintiffs claim caused a taking, was that being done to protect the public?
So the abolition of the PTC
Well,
was
that's
done to protect the public interest.
That's
your
correct.
argument.
It doesn't matter whether, I'm sorry, Judge. Go ahead.
And why is that? Why was the abolition of the PTC to protect the public interest?
Well, I think if you look at the Florida statutes that endow counties with the power to regulate taxi cabs, it's recognizing that local regulation for taxi cabs is the best possible scenario. These counties understand the avenues and the highways where these taxis are going to operate. So the state gets out of the equation, just gives the control over to the counties. But the
PTC was such a unique creature, and the abolition of it was sort of suspiciously tied to, not in a pejorative way, but it was tied coincidentally to the dispute with ride sharing and the PTC's position on that. So
I don't know if I can speak to that, Your Honor. I don't think there's any indication in the record or in the statutes that the dissolution of the PTC was connected to ride sharing. I think that the best way to look at it is the state knew going in that the county gets control, because the Florida statutes governing taxi regulation say that the county gets control. So it abolished this weird anomalous entity and said, the county, you are the ones who are going to decide how best to regulate, because you understand.
putting the counties back where the under 66 counties were before they ever created the PTC.
Exactly right.
But is that for the public interest or is that for legislative sort of housekeeping? For lack of a better term.
I think it is for the public interest, Your Honor, because again, I see that I'm out of time on my 25 minutes.
Right at it.
Yes, may I respond to the question and reserve the rest? I think that the best way to think about this is the state always knows that the county has the power to regulate taxi cabs, and you have to think, what is the reason why the state does that? Certainly, one can make the argument that it's for state legislative convenience. But I think the better route, and you see this in cases like City of Hollywood or Pratt versus City of Hollywood, is recognizing that these are dangerous entities that should be best regulated by the entities that are closest on the ground. And that's the local counties. And when I get back on my rebuttal time, I certainly do want to address the more important point in Penn Central, which is that plaintiffs simply lack reasonable investment back into
Judge
education.
Davis, but remind me, ask one follow-up to that.
At this point, we're giving,
Okay.
you know, we would be unfairly advantaging.
I would certainly be happy to answer on rebuttal. Thank you.
All right, we've got Hillsborough County to hear from now.
Good afternoon, and may it please the court. My name is Rob Brazel. I represent Hillsborough County in the 3326 summary judgment appeal, case number 3326, that is. I think I will shorten my presentation a little bit, and to use the baseball analogy, I think my colleagues are not throwing fastballs at my head here. I don't even know if they're trying to strike me out. They may be okay with an intentional walk, but I will at least give the county's perspective from the briefs and also from the argument today. I think Judge Huey probably said it best in his order when he said there were no medallions for the county to take because, in essence, the medallions had vanished, and they had vanished because the legislature created them, and then the legislature took them away 5 years later. The legislature spoke very clearly, I think, when it granted the property rights, and it spoke equally clearly when it repealed them. There's not a statutory construction analysis to be done here, and my colleagues didn't attempt that, and wisely so, because I think the legislature was fairly clear in what it wanted. The only argument that Gulf Coast and really the state have come back with after hearing the county's brief or reading the county's brief was, well, you failed to honor Hillsborough County, you failed to honor the medallions when you adopted your new regulatory scheme, which they admit put the county basically on a clean slate, basically allowed the county to do essentially whatever it wanted. And Judge Huey even posed the question to me at one of the hearings, I forget which one. He said, well, Mr. Brazel, the county could have said, we're not going to have any taxis at all, couldn't they? They could have said, we're not going to do anything with taxis. We're just going to let Uber and Lyft control the market. And the answer to that is,
formulation, there's a couple of ways by you insisting that the county had a clean slate to say, well, we could grandfather in these taxi cab medallion holders. You could, so doesn't, in other words, who knows what the legislature intended? There's a whole bunch of individual legislators that passed the bill, but presumably you could have just perpetuated the status quo.
well, possibly, Your Honor, but an interesting point on that is that from a sort of a preemption sort of situation where the legislature is driving the train here and the county is the subordinate government, clearly. The legislature said in 2017, we're repealing these property rights. And that was their statement. There's a question, at least in my mind, as to whether or not the county even had the authority to reinstate it. I mean, once the legislature says they're gone, what's the county's authority to then come back and say, oh, no, they're not gone. We're bringing them back. I'm not sure the county had the authority from I don't know if preemption is the right word, but essentially from
Okay, but could the county under I admit I did not do a detailed review of the statutory framework that applies to county regulation of taxis. Would it permit Nellis County to enact an ordinance that granted property rights to medallion holders? Right
Well-
now, like next week, could the Pinellas County Commission say, you know what, We'd like to do what the legislature did in 2012, we'd like to grant personal property rights and the transferability in our medallion holders.
I would think, Your Honor, if the legislature hasn't spoken otherwise, which they did speak otherwise as to Hillsborough County.
Well, how did they speak up? All they did was take away the state grant of personal property rights. They didn't say that Hillsborough County can't itself say, anybody who had this personal property right under the 2012 special legislation has a personal property right, the medallion that says Hillsborough County as opposed to.
They didn't say anything to Hillsborough County, and that's part of the problem, is that, so it's maybe an open question as to whether or not the county had the authority to reinstate essentially the property rights or the medallion rights that the legislature took away. But they could have, the legislature could have said, what we want you to do, Hillsborough County, in starting your own system is we want you to recognize the property rights of these medallion holders. They didn't do that. They did exactly the opposite. They took them away. But part of the problem, maybe from the county's perspective, is that the legislature just took them away and wiped the slate clean and said nothing to the county about what it wanted the county to do. And I suppose it could have. It could have said, what we want you to do is recognize, don't recognize the property rights, start clean, but they really just said nothing. And so that kind of, I suppose, would leave the county in position of wondering what authority does it really have, even if it wanted to, even if it was required to, which by the way, it wasn't. There was no requirement that anyone's pointed to in any argument or any brief that says the county had some requirement that it recognized these rights. But there's an issue there that's kind of an open question, I suppose, Your Honor, as to what was the county's authority to reinstate them, and could they have reinstated them? Possibly. Could Pinellas County allow that in Pinellas? Sure, possibly they could. But I don't want to go off into into a kind of a political tangent, but the local governments are very circumspect when dealing with the legislature, I think, and understanding their authority and sometimes interpreting that narrowly. And none of that's before the court. But just kind of an aside question of what the county's authority might actually have been, even if it was required to or had to, if it had to reinstate the property rights, it would have, because that only would have been by the legislature telling it to do so, which it didn't. The only other arguments that really have come up as to the county were kind of the ones you might expect in a summary judgment appeal, where typically what you look for is on a summary judgment appeal, somebody's going to say there's a genuine issue of material fact somewhere. Well, no one said that here, and not at least until in Gulf Coast's brief. They didn't even get to any genuine issue of material fact question until page 45 of their brief. And then when they did, they talked about the extent of the county's control over the PTC, which doesn't seem to have any relevancy here because neither of those entities created or took away the property rights. But that was some kind of red herring question of fact that was brought up in the brief. And then an issue as to valuation of the medallions, which I think we've talked about a little bit today, not really before the court, and really wasn't before the trial court either. We never got to that stage. So the state's arguments against the county's summary judgment are also somewhat strained and tenuous. The first 24 pages of their 30-page brief, they essentially spend on the motion to dismiss, on the question of whether there was a taking. That seems to be the issue that everyone's more interested in. It's not really the county's issue, but they spent 24.
So it's not the county's issue, but what if we decided that if there was a taking, it was a combined taking and your client is on the hook? Aren't you interested in the tips and coaching argument? There was no taking.
Well, sure. If we got down the road to that point, we certainly would be aligned with the state in saying that nothing.
What road do we go
Yeah.
down if we walk through that door and confer and decide that the county is on the hook if anybody's to be on the hook?
Right, and we put that in our brief. That's in the county's
So
brief.
do you want to argue that there's no taking?
I'm sorry.
Do you want to argue that there was no taking?
Well, we certainly will argue that there's no taking. That's not our threshold issue, but sure, we would certainly argue there's no taking. We put those cases, some of those valuation cases around our brief as well. I think Your Honor may have said it properly, that it seems that the medallion is ultimately intertwined with the value and the ability to restrict competition, which is not what the medallion does. In this case, the medallion is essentially a ticket onto the playing field. A medallion is you get to come compete but it doesn't guarantee you any profits or market share or anything like that. You become subject to, as my colleague said from the state, you become subject to government regulation at that point, and your expectations for what you're going to turn in terms of a profit are really.
I think one of the things that was talked about, at least in the Fifth Circuit case that opposing counsel and I were talking about, and I believe it was that there's two different derivations of value. One is, yes, the value if you're a hot dog stand or a taxi cab, if you get communication with your customers. But the other value is the secondary market, in other words, because no one's saying that these plaintiffs here can't operate cabs. It's just that they don't have the previous privileges that were extinguished in the 2017 legislation. So,
Yes, and that's part of the issue, Your Honor, is that, nowhere in their complaint is there an allegation that they were restricted or currently restricted from operating cabs in Hillsborough County. Under the new system, everyone's been invited in, welcomed in, and anyone who was driving before could drive now. And so there is no suggestion that our ability to earn a living.
so if they're your ordinances, your county's ordinances, is there an appreciable difference in the regime that would give rise to, if the facts could be developed, a taking? In other words, if under the 2012 regime and the post 2017 legislation ordinance regime, was there some guarantee of participation of medallion holders had post 2017 ordinance that they now don't have?
Well,
What rights did they have in 2014 that they no longer have now in 2021 after the ordinance passed by the county commission after the 2017 legislation?
I don't know of any. I don't know of anything that's different for them. They were driving before, they're driving now. The problem that they may ultimately find in this case in terms of damages is going to be that, around 2017, I think as Judge LaBritte was alluding to, Uber and Lyft were starting to flood the marketplace. They've done so even to a greater extent now. So now, to the extent that you were holding a medallion, let's say that you could sell to somebody, what would you sell it for? What amount would anyone be willing to pay for it? Given that you've got Uber and Lyft running around essentially under different rules, they're not really subject to. They weren't subject to the PTC rules, and they're not subject, I don't think, to the current ordinance. It makes valuation a little.
Wasn't under the previous ordinance, weren't there some provisions that gave the commission, the governing body, the ability to restrict entry to the market? Was something based on population. I don't want to call it a cap.
Right, there was, I think, some limitation, not in our record, but I think there was some limitation on
laws are in our record.
Yeah, I think there was some limitation though on the number of medallions that.
So is there a similar restriction under the current regime instituted by the county and its ordinance?
There is not, but also I think under the old PTC regime, I don't believe that all of the available medallions were ever even issued. So essentially, it's whoever wants to drive can drive, and that's the situation today. And essentially, that was the situation under the medallions before. So that's a whole nother road to travel down. But essentially, the Gulf Coast and all their folks were driving before, and they drive now. And they operate the same type of vehicles in the same way that they operated before that they operate now. So anyway, I'll just kind of close with some sort of a more simplistic type of analogy. I think the arguments coming from Gulf Coast and particularly the state, where the state is saying, if there was a taking, we didn't do it, the county did it, is a little like saying, something's red and we can clearly see it's blue. You can read the words on the page. The legislature wrote down what they did. They made it clear to us what they did. It's not mysterious. Really, whether you make it more simple, as the county, I think, is trying to do, or more complicated, the county really believes the result is the same. Judge Huey's ruling on the county summary judgment motion should be affirmed. Clearly, no genuine issue of material fact, and clearly the legislature granted the property rights and took them away before the county began regulating.
Thank you.
Thank you.
All right, we circle back now to the state for rebuttal.
Since would you mind me asking a question of the gate? I'll go ahead. If you could reframe the conversation we were having when your time was extinguished, I think we were having a discussion about half of the test, sub-test, whatever, was the regulation that allegedly resulted in the taking undertaken by the state for the benefit of the public. And, that's debatable, but would it also be profitable to say what it is not? In other words, there's two sides then. Was it for the benefit of the public, or was the alternative? And whether it was whether it was not that, is maybe just as important as whether it was for the benefit of the public.
Your Honor, I think that the key consideration is what was the intent of the legislature? What were they trying to accomplish? Certainly, what the legislature.
But let me just. What is the test? I'll just confess ignorance or a memory lapse. The test is a dichotomy between two things. One, was it undertaken to benefit the public? And the alternative is, was it undertaken to benefit the beneficiary who's saying his or her property is taken? We were fixated on whether it was undertaken to benefit the public, but isn't there other side of the coin?
If I can slightly reframe the issue, I think that the dichotomy was the action taken to protect the public, as opposed to was the action intended to create a public benefit for all people at the burden of just a few. And here, the best way to look at this is it was done to protect the public, because transferring control to the county isn't something that you typically think of when you're benefiting, giving
Thank
benefit.
you for reminding me. So that's what I was trying to get to. We were fixated on what you think it was, but there is another side to that test, which is what you think it was not, which was not a taking of something to benefit the public at the expense of the person from which it was taken.
Right, because when you
That's a
think.
more clear question.
Sure, and I think that's totally right, Judge Atkinson, because when you think of regulations done for public benefit, you think of the government coming in, taking your house to build a road. That's for the public's benefit. It's not done to protect them. It's for their convenience. We think the best way to look at the issue here is that the government was acting to protect the public by giving control to the entity closest to the
Given the
ground.
choice between the two, it fits, even though it's not a perfect fit, that it's for the protection of the public. It's certainly not for the benefit of the public at the expense of those alleging the taking.
That's absolutely right. And I think, because of both of those reasons, because we have strength on both the sides of the coin, I think that the government action prong cuts very strongly for the government.
Going back to Penn Central, which is back to what Judge Lewis mentioned.
Exactly. And that's all, and what we were talking about here is all in Penn Central. That's the first prong, character of the government action. The second prong also cuts for the government, because the plaintiffs lacked a reasonable investment-backed expectation that their medallions would retain go in value and as a going concern. And we know that on a few levels. First, Lucas said that personal property owners already have a diminished expectation in their personal property, given the government's ability to control the realms in which personal property is used and exchanged. And that's different from land. The personal property owners have a diminished expectation in comparison to landowners who have a very strong expectation that their property retains value. But that's even more acute here, because like we were talking about before, plaintiffs lacked so many of the key sticks when they entered into this highly regulated scheme that they simply had no expectation that the scheme would remain static. And that's exactly what the court held in peanut quota holders from the Federal Circuit. There, the court said, look, even if these peanut quotas are property, plaintiffs lacked a reasonable expectation that they would retain value, because the government always reserved for itself the ability to change that licensing scheme and to change that peanut quota scheme within the regulatory scheme itself. And so there was no reasonable expectation that the quotas would retain their value. And of course, that's exactly how courts who have considered this issue in the taxi context, how they've approached it. So if I can quote the Boston taxi cab owners case, the court there said that any reasonable expectation held by plaintiffs in their medallions must be significantly tempered in light of the decades-long, highly regulated nature of the taxi cab industry. That's exactly what we have here. And of course, that's totally consistent with this court's decision in Galaxy Fireworks, because there you had a field that regulated fireworks, which are dangerous entities. It's a highly regulated field. The plaintiffs brought a taking when the governor put a moratorium on the sale of fireworks. And the court said, you don't have a taking here because you lacked reasonable investment-backed expectations. And to quote, fireworks are a heavily regulated business. And so plaintiffs were on notice of the possibility, if not the probability, that further regulations could be enacted from time to time and devalue their property. You can just plug in taxi cab medallions for that exact statement. Taxi cab regulation is a heavily regulated business. Taxi cab operation is a heavily regulated business. So plaintiffs were on notice of the possibility, if not the probability, that future regulation could render their medallions valueless. So I see that I'm out of time. I know that I didn't get to discuss whether the county has done it, not the state. We'll rest on our briefs for that. I think the easiest way for this court to decide this case is to rule that there has been no taking, and if not, to reverse the grant of summary judgment for the county. Thank you.
Yeah, you get the final word.
Yeah, I want to start with Dennis Malikon. Quote, I'm quoting from the case. The city historically has viewed and treated a medallion as a privilege rather than a form of constitutional protected property. Here, the legislature said the exact opposite of what the city of New Orleans said. The legislature declared in the law this was private property, and that is the linchpin of this case. And I will submit, Judge Askin, you go through all these cases, you will not find, as the state just said, they conceded it earlier, you will not find any case where a legislature has done what our legislature has done. It's declared it private property. Our legislature is allowed to do that, even if the attorney general doesn't want us, as legislature, to do it. It's up to the legislature, not the executive branch, not this court. I'd also point out about Dennis Malikon and the city of Boston, and this ties into some of the arguments the county's been making. Those were cases seeking preliminary, injunctive, and declaratory relief. We're not seeking that. Those are cases where you're trying to say, this isn't for a public purpose. We're not saying that. The government is allowed to take our property. That's not what the takings clause, the takings clause doesn't prevent that as long as there's a public purpose. And I heard all this discussion about public benefit. We're not challenging that the state could reorder things and that this was a public benefit and all that. But when the government takes my property, they're allowed to do it. They can come take my driveway. They can come take my front yard. They can take my home, but they have to pay me compensation. And that's this claim.
But Penn Central is about whether they have to pay compensation.
Penn Central
talks about whether it is conferring a benefit for the safety of the public, the protection of the public versus conferring a benefit on the public.
Right, and I want to get to Penn Central, but I want to point out the cases you're relying upon, they weren't seeking compensation. They were seeking injunctive and declaratory relief, and they
Taking itself.
yes, and there was no law written like our law here. We don't agree that Penn Central applies, and I want to explain that in a moment. But if you do agree, and I heard you bring up the Scott case, Galaxy Fireworks, that case came to this court on a summary judgment, got reversed, and is based on a full bench trial, all those facts. We're here on the pleadings. And I'm hearing all these arguments that are pure speculation without any expert testimony, without any record, just the
Well,
pleadings.
let me go with that. Let me go back to Dennis Malikon, which you led with, and say, for the sake of this discussion, we'll presume that your experts will talk about the exorbitant value of these medallions on the secondary market. I think you would concede that what has been your client has not been deprived of the benefit of profit by way of charging people to drive them around.
Your Honor, if we show that there's a taking, that's a nominal damage. And if we don't, just like in the interest case,
So it all comes down to, sorry, in the interest of time, it's a taking of something that because the legislature labeled it property.
right, and I want to.
Is that what it comes down to?
Yes, and yes, it does. I want to read this from the Lingle case, because I think all these tests, Lucas, Penn Central, they all get lost in what the takings clause and first principles. And this is what the court said in Lincoln, I'm sorry, Lingle, 544 US 528. It says whether it's Lucas, Penn Central, Loretta, all these tests that we've devised share a common touchstone. Each aims to identify regulatory actions that are functionally equivalent to the classic taking in which the government directly appropriates private property or ousts the owner from the domain. We have cited on page 27 and 28 in note 5 of our answer brief in the state's appeal and in our reply brief in our appeal, pages 14 and 15, many cases where the government destroys property, that's a taking. What has happened here, and I want to read the very last words from Lingle, oust the owner from his domain. We were given a domain by the legislature in 2012. We were told this was an assignable sale, devise, all those bundle of rights. And then the legislature repealed that. What's that?
All those bundle of rights?
Well, I'll read it.
No, but you just raised the issue about whether you had all the bundle of rights.
We did.
Right to exclude it.
It says right here, the medallion, I'm reading from the statute, Your Honor, may transfer the medallion, quote, by pledge, sale, assignment, sublease, devise, or other means of transfer. That's a bundle of property rights.
I think what Judge Atkinson's point is that in the traditional notion of the bundle of rights, that you would think of land in kind of the stock claims, that one of the key sticks in the bundle of rights is the right to exclude others, and which these medallions don't give you. I mean, you don't have any.
And it's no different than the shares of a corporation. I have the shares of a corporation. I could have 1 million competitors in the same business with me. But if the state comes like they did in Cuba, I have another case going on with that, where they directly appropriate the shares of your company, that's a taking. And that's what this is. It's just pure and simple a taking.
Time, recognizing the distinction with Dennis Malencon, that in that case, the governing body of the city did not denominate these things.
Correct.
As private property, did not give them that label. Your opposing counsel has brought up the fact that property means different things in different contexts. If the teacher has a property interest in the person in retaining her position, she can't bring a takings claim if she's fired. But she can have due process before they take the property interest in her job. So property doesn't mean a compensable, cognizable property interest that brings you within the end of the takings clause. Is that correct?
There's a lot of layers to that question, and I don't think I want to concede that's correct. I think a teacher does have a property right in the money that's owed to her for her salary for work performed. So if they didn't pay, if the state refused to pay the teacher, it's possible that could be a takings claim.
Is this along the line of that franchise distinction?
Right. If I have a right to money.
But that was a condemnation proceeding where the government conceded that it was taking property.
Sure, and here we don't have the government being so honest, though they did sell these medallions.
This isn't a condemnation, isn't it?
No, but I think my point, Your Honor, is I think we're actually pretty darn close, because the legislature passed a statute that said we're repealing this property right. That's what they did. They repealed the property right. And I guess just to give you another historical example.
You'll need to make this your last one.
All right. Sure. Sorry. Thank you. When the original settlers set up, they came here, the king gave them a grant of land. And that 5 years later, the king had revoked it. That would have been a taking. Here, the king is the legislature. It granted a property right, and 5 years later, it took it. It's a simple case.
Thank you all. That is the last case on the docket today. And with that, wish you all happy travels and stay healthy. We are adjourned.
All rise.